Okay, so this next video lecture is about our partnership topic. Okay, so this is another form of business organization. So in our Philippine Civil Code, this is where we can find the definition of the term partnership. So in Article 1767, partnership is by the contract of two or more persons wherein they bind themselves to contribute money, property, or industry to a common fund with the intention of dividing the profits among themselves. So from this definition, we can have some of the elements of the partnership. First, partnership is a contract between two or more persons. So meaning this is an agreement between these parties. Two persons can form a partnership or two or more persons. So under this definition, there is no limit as to the number of partnership that can form this type of business organization. So with this contract, they are, or part of their agreement is to contribute, or in this case, when we say contribution, this is what they bring into the business as their investment. Okay, so they can contribute money. Okay, that is the basic investment that one can make in a business. Aside from money, a partner can also contribute property. So this is this property are the assets that once contributed by the partner will become the property of the partnership as a whole. Okay. Aside from money or property, the partner can also contribute industry. When we say industry, this is the expertise of the partner, okay, that he possesses. This is normally an expertise in different areas or profession in which this can be used in performing the partnership's operations, okay, in their business. So these are the types of investment or contributions that can be contributed by the partner in the partnership. So once these are brought into the partnership, this becomes their common fund. So again, this is now the assets or the property of the partnership. Okay, and not only to the partner who contributed it. So aside from contributing or investing something in the partnership, this contract also has the intention of dividing the profits if they have among themselves. So the division of profits will depend on the agreement of the partnership on how many percent or what portion or part of the profit will be given to a certain partner. So these are all part of the contract of the partnership. So it should be clearly stated. Okay, specifically, this should be made in writing so that the partner will be reminded every time, okay, about their agreement. So this is how this is how we define partnership. So again, this is a contract between two or more parties in which they bind themselves to contribute money, property, or industry to a common fund with the intention to divide the profits among themselves. So this is the nature and characteristics of a partnership. So two or more persons may also form a partnership for the exercise of a profession. So this is what we call general professional partnership. These are the partnership of accountants, An example of this is the CPA firm. It can also be a partnership of lawyers in a law firm, doctors, and other professions to perform or exercise their profession. Okay? So, nature of partnership. Within the context of the Philippine law, so a partnership is treated as an artificial being. Okay? When we say artificial being, meaning a partnership is viewed also just like us humans. Okay, so they can be treated as a person. Okay, but in this artificial being is created by operation of law. So we have that's why if you could notice, the definition is coming from the civil code. Okay, so again, a partnership is treated as an artificial being or just like as human, but they are created by operation of law. So they also have a legal personality that is separate and distinct from the partners. Meaning, for example, the name of the partnership is XYZ partnership, and the partners are partner A, partner B, and partner C. So in this case, if we will look into this case, we have 4 separate legal personalities. We have the 3 partners, partner A, partner B, and partner C, and the partnership XYZ. So that's why in this case, they are considered to be and treated as an artificial being. So therefore, they have this legal personality that is distinct from their owners or the partners. Okay, please take note of that. So it proceeds from the concept that persons may be allowed to pool their resources and funds to engage in the pursuit of a common business without organizing and without organizing a corporation. So they can form a partnership, okay, upon which the law imposes much higher form of regulation, the corporation. Okay, so Philippine partnerships operate under the concept of unlimited liability unless otherwise agreed upon by the partner or the partners. Each one of them acts as a manager and agent of the partnership, and consequently, their acts bind the partnership. Basically, in a partnership, the general partner has the unlimited liability. When we say unlimited liability, meaning the creditors can run after the personal assets of that partner. Okay, for example, the partnership is bankrupt, meaning they have negative equity balance or deficit, and there is no assets left to pay for the creditors. So in this case, the creditor will collect from the general partner even up to his personal assets. When we say personal assets, these are the assets that belongs personally to the partner that he does not contribute in the partnership, because normally in a business setting, once the business is bankrupt, they can no longer go after the personal assets of the owner. Okay, so this is in the case of a corporation, but in the case of a sole proprietor and a general partner in the partnership, they can run after the personal assets. Okay, even those assets which were not contributed in the business can be paid or can be run after by the creditor. Okay, so that is unlimited liability, but this is applicable only to the general partner. General partner, we will discuss that in the next sections, okay, of this file. Okay, so also please take note that in the partnership there should be a designated manager that will take over or take charge of the day-to-day operations of the business. Okay, and whatever that managing partner is doing, that is binding to the partnership, meaning he acts in behalf of the partnership. Okay, so whatever that he do, it will also as if that the partnership is doing it. Okay, but in this case, this is represented by the managing partner. So that is the nature of partnership. So what are the characteristics of partnership? So some of this was part of the definition that we discussed earlier. So in a partnership, there is no time limit for their existence. This will depend on the agreement of the partners. Okay. And another is partnership becomes a juridical person from the time the contract begins. So meaning once that the partners have agreed to form the partnership, a separate distinct personality of the partnership will begin to exist. Another is when a partner may transfer his interest in a partnership to another. The transfer does not automatically become a partner unless all the other partners give their consent. Meaning, for example, we have three partners A, B, and C. So in this case, partner C now will transfer his interest to his son. Okay, but before his son can be admitted in the partnership, there should be an agreement and consent from partner A and partner B that they agree to this transfer. Then if there is no agreement or consent, then he cannot transfer his interest. Okay, or there can be no admitting of new partner in the partnership. So this is the nature of partnership. They have to agree everything and consent on everything before it can be done. Okay. Another is as to liability to third person. Partners may be held liable with their private and personal property. This is in the case of a general partner earlier where they have the unlimited liability. Okay, so the creditor can run after the personal assets of these partners. Another is partnership may be dissolved due to insolvency, civil interdiction, death, insanity, or retirement of the partners. So you will have a thorough discussion of this in the computation part of the partnership. But of course, in this case, when the partner or when the partnership is insolvent, meaning there is no assets left to pay for the creditors, then this time the partnership can be dissolved, meaning there is no contract of partnership anymore that exists. Okay, civil interdiction is this one may be done if this is a damage done by one partner to the partnership or to the other partners, or damage done by the outside party that makes the partnership to be dissolved. Okay, death of a partner. Okay, meaning because in this case the agreement, for example, is between partner A, B, and C. The agreement of partnership is between the three. So once one of the partner is out, so the agreement is now dissolved because it cannot apply to the remaining two partners. For example, if the two partners would want to continue the partnership, they have to create another agreement. This will become a new partnership between them. Okay, because the original agreement is between the three. Okay, that's how dissolution in a partnership takes place. So insanity also of the partner, one of the partner, or the retirement of one of the partner, okay, will create a dissolution of the partnership contract. So what about the formation? How to form and the requirements, okay, for partnership. So partnerships are required to be registered in the Securities and Exchange Commission. So registration is done by filing the articles of partnership. So articles of partnership, this is where the agreements are written, everything. Okay, so the articles of partnership set forth all the terms and conditions that was mutually agreed by all of the partners. More specifically, the documents required, okay, for filing are as follows. So their articles of partnership, the name, okay, of the partnership, bank certificate of deposit, okay, for foreign certificate of registration, okay, if that is a foreign partnership. If proof of inward remittance in the case of non-resident or foreign also partnership. So these are just the common requirements that are needs to be filed once a partnership is formed. Okay, so if there's nothing, that corporations are not allowed by law to become partners in partnership. Actually, in this case, but normally the partner should be a person. Okay, so partnership may be, corporation may be a partner, but in a partnership, but this is seldom, okay, in the Philippine setting, I guess. So we go now to the different types of partnerships. Okay, so we have the general partnership. Okay, general partnership, this is the simplest form of partnership. They are the easiest also to form and cheapest to maintain. They are simpler than corporations, even other types of partnerships. So a general partnership is formed immediately when partners begins business activities. That's how easy it is formed. So there is no official paperwork required, only general partners. So these are the general partners who will absorb the liability up to the extent of their personal liability or personal assets, I mean. So they have the unlimited liability. So the low upkeep cost is mainly due to the fact that there is no there is no official state filing needed to create this type of partnership. So this means there are no filing related costs. Similarly, there are few ongoing requirements. For example, it is necessary to hold an annual general meeting. Okay. Additionally, general partnerships are easy to dissolve as well. Okay, so they can be broken up anytime. So while this arrangement is the simplest, there are some major disadvantages, however. So all partners in this type of partnership are general partners. So all of them have unlimited liability. Okay, this means they face potentially unlimited liability in this arrangement. Okay, so additionally, all partners are fully liable for the actions of any of the other partners. Finally, the business is dissolved if any of these partners declare bankruptcy or they will be out of the partnership. Fortunately, there are ways to prevent dissolution in the case of bankruptcy or and a partner would want to or don't want to continue to become a partner. So a partnership agreement usually accompanies this type of business arrangement. Okay, partners can include clauses that state that the business will continue after the death of a particular partner and that provide a process where the interest of this partner will be distributed among the remaining partners. So in this case, it should be clearly stated in their agreement. Or else, if this case happens, there will be a dissolution of partnership. Okay, so the second type of partnership is limited partnership. So in limited partnerships, this provides a more protection on the part of the partners. So because there is at least one general partner, only one general partner. Unlike in the general partner, all of them are general partners. In a limited partnership, only one is required. Okay, so the general partner will manage operations and takes also the unlimited liability. So the remaining partners are limited partners, meaning the creditors can run after only up to the investment or up to their investment in the partnership, and the creditors cannot run after their personal assets. Okay, that is the limited partners. So limited partners share profits of the company but can only lose as much as they invest. Okay, so that's the beauty of being a limited partner. So finally, unlike general partners, where there are very little paperwork involved, this type of partnership requires state filings. Okay, what about limited liability partnership? So in this case, limited liability partnerships are the extension of the general partnership. So this is essentially a general partnership where all partners are protected from actions of other partners. Essentially, all partners have limited liability. Okay, this is different from the limited partnership where there should be at least one general partner. But in this case, they are all limited partners. Okay, so in this type of partnership, partners maintain their flow through taxation status, which makes them very similar to limited liability companies. But in the Philippine setting, they are treated the same, okay, since they belong to partnership, or like the corporation, I mean. So while this type of partnership may seem enticing compared to the first two, so some in the United States setting, they restrict them, okay, to certain professions like lawyers, doctors, and accountants, because these types of professions or these professions should belong to the general partnership. Okay, so those are the three general types of partnership. So what are the common types of partners? So in this discussion, I just only include the common types. You can also, if you can try to search, there are a lot of different types of partners. Okay, but of course, in a partnership, there is a general partner. So we keep on mentioning this. Okay, if you could notice earlier. So when we say general partner, this partner is involved with the operations and share in the profits, and he has the unlimited liability where the creditors can run after his personal assets. Okay, we also have the industrial partner. This is a partner that furnishes his labor or industry. If you could still remember, this is the partner that contributes his industry to the partnership, labor or expertise. Okay, another is the capitalist partner. So this is the partner who gives his capital, okay, neatly in the form of money or property. And the limited partner, so his liability is up to only his investment in the partnership. So in this case, the creditors cannot run after his personal assets. So those are the common types of partners, but there are a lot of other partners like managing partners and so on. So what are the partners' liability? Okay, so in fact, we have discussed this in the different types of partnership, if you could still remember. Okay, so as a general rule, the liability of partners in the partnership should be unlimited. Okay, so in that case, the creditors may run after their personal assets. But in the case, however, of a limited partnership, so the law allows the limitation of the liability up to the extent only of their contribution or investment to the partnership. So again, the unlimited liability will be on the general partner. What about dissolution? Okay, how to dissolve the partnership? So we also have mentioned some of this and in the previous earlier. So in Philippine law, so they allow dissolution of partnership for any reason, provided such dissolution does not amount to a breach of contract or is prejudicial to the third parties. So one reason for dissolution is the death of a partner or the unauthorized transfer of ownership his share of the partnership. So this will result into a dissolution. In other words, any change in the composition of the partnership, unless so allowed, will result in the dissolution. Consequently, the remaining partners may form a new partnership if they wish to continue, okay, the venture. So in this case, we have if one of the partner is transferring his interest to another person, or in general, or in a simpler explanation, if one partner will go out of the partnership in any way, that will result into a dissolution of partnership. And if one party wants to join the partnership, that will also dissolve the partnership. Again, when we say dissolution, it means to say that the contract of partnership will be of no effect. Okay, so the existence of partnership will come to an end. That is dissolution. Okay, so again, dissolution of partnership will occur if one or more partner will come out of the partnership in any way, or one person would want to join the partnership. Those are the general reasons that are acceptable within the bounds of law, okay, that will create a dissolution in the partnership contract. So those are for the basic theories for our partnership.